Welcome back to Unresolved, the Diddy cases. I'm Kelly Hyman, your host. Along with me today is Paul Callan. Paul Callan is a prominent trial attorney, legal analyst, and media commentator with decades of experience in high-profile civil and criminal litigation. He has represented high-profile clients, including Leonardo DiCaprio, Quentin Tarantino, and Ivana Trump, and served as co-counsel to the Nicole Brown Simpson estate in the civil suit against O.J. Simpson. Welcome, Paul.
My pleasure. Nice being with you. Yep.
Let's talk about the prosecution's case. Can you walk us through the different causes of actions that have been brought and what they need to do to prove their case?
Well, it's a complex indictment in that they've used a number of different statutes, and they start out with a racketeering statute, which came into being really in the prosecution of organized criminals in the United States. And now it's used for such a variety of things. So they're saying he's guilty of racketeering, RICO racketeering. That's one count. There are, I believe, another 3 counts then of sexual trafficking, which involves using force or fraud or coercion to get somebody into a sexual relationship. In general, that's what that crime is. And the final crime, the final charge, is called the Mann Act, which has been around since I think about the 1920s. It was originally called the White Slave Act. And if you cross state lines for the purpose of prostitution, or you engage in having somebody cross those state lines, that's a violation of the Mann Act. So that's sort of the big picture of what he's charged with. 4 women are being used as the primary witnesses against him, and he could spend the rest of his life in prison if he's convicted on these charges.
Do we have any idea of who are going to be the victims that are going to testify?
Yes, we know that there are 4 women involved. One woman has really very much a public persona, and that's his former girlfriend. And you may remember, and a lot of our audience here may remember that tape of Sean Diddy Combs kicking a woman down a corridor in a hotel and pulling her hair. That was his girlfriend, Carrie Ventura. She's really the strongest witness against him, in my opinion. There are 3 other women who have brought charges who were not really public figures in any way. So that's how that lines up. Now, they're trying to say that he was engaged in these things called freak-offs, which were these large parties that were held largely in hotels with a number of people engaged in sexual activity. And prosecutors claim that he used coercion, force, threats of force to get women and other people to engage in sexual activity in these parties that he sponsored. And he says that, a lot of women went along with it because maybe they wanted to advance their careers. I mean, they'll offer a number of reasons for why women got involved this way. And by the way, there were men engaged in sexual activities too at these parties.
Why do you think that Ms. Ventura will be the strongest witness for the prosecution?
I say that because there's video of her being abused physically by Sean Diddy Combs. And most of the rest of the case involves sort of a he said, she said fight over whether something was coerced or whether it was consensual. But she has the clear video of this happening. Now, it's an interesting story behind the video, Karen, because CNN obtained a copy of the video, even though Sean Diddy Combs had purchased it allegedly for $50,000 from the hotel where it happened. And they aired it. And that really was kind of the start of this whole downfall of Sean Diddy Combs. So she's got corroborative evidence supporting at least one aspect of her case, and that is the use of force. For the other women involved, the cases are not as strong.
Why do you think the judge allowed that evidence for the jury to see during this trial?
Well, it's an interesting question because there was a big argument in court about this, and Sean Diddy Combs's lawyer said, "Hey, this reflects an unfortunate thing that happened in the past, and it's not reflective of what was going on in 2024 and 2023 at the time these freak-off parties were occurring." And that it would be highly prejudicial to show it to the jury. Now, the judge didn't agree with that and said that he's going to probably admit the video at the time of trial. But there are a lot of other witnesses who may be called in this case because there are estimates of anywhere from 5 to 10 weeks that the case is going to take. So there are a lot of witnesses who will be called about these parties and about the kind of behavior that Sean Diddy Combs engaged in, which prosecutors say was criminal.
So let's talk about Miss Ventura. Now, she filed a civil lawsuit against him, which settled right away. Most likely, she signed some type of NDA where she's not supposed to disclose everything. How does that play in the criminal case? I mean, could she be in violation of that? How can she testify if potentially she signed some kind of don't discuss this, don't discuss the facts? How is that possible?
Well, it's quite possible because generally speaking, the law will not enforce any kind of an agreement that would prohibit a witness from testifying in court under oath and under subpoena. So I don't think that that NDA, non-disclosure agreement, is enforceable in this criminal case. I do think, though, that when you step back and look at this case, it really looks bad for Sean Diddy kind of from a distance. But as you get closer, I don't think the case is as strong as a lot of people think. It's going to come down to testimony of 4 people, and the defense is going to attack Ventura and say, listen, she accused him of rape. She settled the case for a lot of money and said she would not disclose anything. And now she's coming back at him in a criminal case. And this may give the jury pause to think that she's just money motivated and revenge motivated. With respect to the other women, I think the jury is going to hear claims by the defense that they're just in it for the money and that they knew and consented to going to these parties and to engaging in this sexual conduct. So, I think the defense can put a lot of strong arguments on the board here in defense of Sean Diddy Combs. Personally, I think his biggest problem are the huge number of civil cases that have been filed against him by other women, not criminal cases, civil cases for money damages that he'll have to face even if he's acquitted in this case. So he's going to be tied up with these allegations for a long time.
What is his defense in regards to the RICO charge that he had this enterprise and use that enterprise to further allege criminal behavior and work with people in his organization to help further allege arson and types of crimes like that?
Well, I think that his claim is going to be to the jury that, this RICO statute, this racketeering statute, was designed to get organized criminals who engaged in horrific activity like murdering people and extorting money from them. And what's going on here? Well, he's throwing a party, and now, admittedly, he's engaging maybe in sexual conduct that the average person doesn't engage in, but it's a party that people were voluntarily coming to. And yes, he used some of his employees and some of his associates to put the party together. Now, that's a use of the RICO statute in a very different way from when you're prosecuting John Gotti and you show that his soldiers, in the Gambino crime family, organized an extortion racket on small business owners. Okay, that's where this statute came from. Against Sean Diddy Combs, they're saying, hey, he throws a big sex party and he uses his employees to invite guests, and all of a sudden he's John Gotti. They're discriminating against him. They're going after him. There's something wrong with this. That's the approach I think you're going to see the defense take, and it may resonate. Remember, the jury here is predominantly a Manhattan jury, and depending upon who he gets on that jury, he may get people who will sympathize with that approach.
Who do you think the prosecution want as potential jurors or jurors to sit, and who do you think the defense wants as potential jurors?
Times have really changed in this regard. I mean, I remember when I was starting out as a prosecutor in New York City, we were not afraid to put women on a jury on a rape case because, or rather, as a defense attorney, we were not afraid to pick a woman for a case like this because they really are hard on other women sometimes. They really are skeptical about women, and especially older women. So from the defense standpoint, you'd be looking, I think, for older women who might be skeptical of the claims of the younger women who come in and testify. But whether that old saw that women don't trust other women is still legitimate, I don't know. The Me Too movement changed public attitudes quite a bit about what women have to go through frequently in the workplace and in other situations. And I think it's hard to say now that women or even older women would be on his side. So this is a real tough question as to who you want on the jury. I think you certainly he'll probably be trying to avoid people who are big, rap stars and into music that's popular in the Black community. But on the other hand, there's case law that you can't discriminate somebody against somebody on the basis of race in the selection of a jury, nor can you discriminate on the basis of gender. So I think they're just going to be looking for reasonably intelligent people who are going to not be influenced by press coverage and take a hard look at the facts and agree to apply the law rigorously as it will be given to them by the judge.
And who does the prosecution not want on the jury, and who does the defense not want on the jury?
Well, I think prosecutors will want to avoid people who they think are really enamored of rap stars and of the whatever their perception is of the rap culture. I think prosecutors would be looking for more conservative people, maybe people who don't have a college education and who may resent somebody like Sean Diddy Combs and his money and his arrogance, really, in the way he's been treating these women. So I think that's sort of what prosecutors may be looking for. On the other hand, the flip side of that is the defense will be looking for, I think they'll probably be looking for members of the Black community who are into rap music and admire Sean Diddy Combs as somebody who rose up from nothing to make his own business and become a success. And I also think they'll not necessarily just be looking for Black people, but they'll also be looking for young white people who are into music culture in Manhattan and who are likely to be sympathetic to him.
Who do you think is going to start the case from the standpoint for the prosecution? Who's going to be their first witness?
Well, when I was trying cases as a prosecutor, my rule was start strong and finish strong. And I think the strongest start to this case would be with his girlfriend Ventura and that video of him abusing her in a hotel hallway, dragging her down the hallway, kicking her. Remember, he kicked her several times. It's really a brutal piece of film. I think that would set the stage for the case and the prosecution. So I think that's how I would start the case as a prosecutor. And how you would end the case would depend upon how other evidence went in.
Will Diddy testify?
Well, defendants in criminal cases always say to the press and to others that they're going to testify or they're thinking about testifying. There's no way on God's earth that Diddy will testify, in my opinion, because remember, there are a number of other lawsuits out there against him claiming similar behavior, and heaven knows what his prior, personal history may be that prosecutors have. Remember, this is the federal government that's up against him, and so they've looked in his life back to the time he was a child, probably, to find bad acts by him that he can be cross-examined about. And even if you didn't go back that far, as somebody who's a kingpin in the rap industry, there'll be a lot of dirt to throw at him and make him unbelievable as a witness. So I would be shocked if he takes the witness stand in this case.
So then, based on that, who would Diddy have for his case to testify in his defense?
Well, there's talk that a lot of his celebrity friends might be called as witnesses. A lot of names came up during the jury selection process. Um, they might be able to come in and contradict some of the things that were claimed by the four women who are bringing the charges. And if he could get another celebrity on the stand who would awe the jury and say, hey, I was at that party and none of that happened. There might have been things happening in bedrooms that I'm not aware of, but Sean was not, a part of that or responsible for that. And, all he's got to do is, for the most part, establish that he wasn't using force, coercion, or fraud to get people to come to these parties and engage in sexual activity. So I think it's quite possible that he'll get some well-known people, friends of his, to come in and say, I'm very familiar with him. He's got good character, and yes, he may have engaged in some kinky sexual activity, but it was all consensual. So that's where this defense is going to go, I think.
And what themes do you think you're going to see from the prosecution, from the opening arguments, and themes from the defense in their opening statement?
Well, the prosecution, I think, is going to sort of take on a Me Too theme, which is that this is utterly indefensible, that women would be coerced and treated the way they're going to prove, that subject to force, using the fact that they aspired to rise in the music business, to get them to engage in non-consensual, really, sexual activity. So that's what the prosecution's theme is going to be. I think that on the defense side, trying the case at least to a jury who may be substantially from Manhattan, the Southern District where it's being tried is populated primarily by people from the Bronx and Manhattan. Now, there are 5 or 6 counties upstate that bleed into the Southern District, but most of the population's in that area. So I think they'll appeal to this Manhattan jury and say, hey, Manhattan is a place where a lot of people in different cultures from different backgrounds engage in activities, consensual activities that may be frowned upon by other people. But that doesn't make it criminal. That just makes us a diverse, interesting cultural area. And you can't be putting everybody in jail who has a party which results in people having sex with each other. So I think they're going to appeal to that. So that sort of, you're living in Manhattan, you got to be open-minded about different strokes for different folks. And that's what I think the defense will be.
Well, thank you, Paul. Is there anything else that you can think of that would be important for our viewers to know about the case?
A couple of things struck me. The federal judge in the case is a really interesting guy. He's only 46 years old, very young, really, for a federal judge. And he has tried some of these sex trafficking cases before. People in the Southern District that I've spoken to have tried cases in front of him. They say he's a very fair guy and extremely bright and knowledgeable of federal law. I think he's going to be a good judge and a fair judge, and he'll be somebody to watch. He clerked, by the way, for Ruth Bader Ginsburg when she was on the Supreme Court. So he's got solid credentials. Went to Columbia Law School. So he's a smart guy, appointed by President Biden, so I think he's somebody who's not necessarily going to try to bury Sean Diddy Combs. I think it'll be a fair trial. It'll be a fair trial that we'll get from this judge.
Why do you think the judge did not sequester the jury?
Well, sequestration of juries is a very, very rare thing in the modern age. I will tell you, when I started out as a prosecutor, every jury in New York that deliberated in a criminal case was sequestered for the period, at least, of the jury deliberation. Now, we had one of the strictest sequestration rules in the country, but the public really got fed up about that, and because it's really, an imposition on them to be confined during the course of a trial. And so now there have been a lot of big cases that have been tried across the country. O.J. Simpson, which people may remember, even in that case, the jury was not sequestered. Jurors are instructed every day not to read the media, not to be out doing computer research and other things to get information that doesn't occur from the courtroom. And we seem to be able to try these cases without sequestration. So I don't think there'll be a sequestered jury in this case.
Thank you, Paul. Let's welcome Judge Ashley Willcott from Court TV. Ashley, it's so good to see you. Thank you so much for joining us today.
Listen, I love you and your podcast. Thanks for having me.
So let's talk about jury selection. As a former judge, can you walk us through the process, what happens, how it works?
Absolutely. So every state's a little different, obviously, but there's some things that are very uniform, regardless of what state you're in. And these are things like, as you well know, Kelly, the jury questionnaire. That's how it starts, because the court has to have basic information about each potential juror. So that's the demographics, it's answering questions. And it can be specific to a specific case. So for instance, if there's a case against the tobacco industry, there may be questions about whether or not you're a smoker or a tobacco user, whether or not you've ever been involved in a lawsuit, et cetera, et cetera, et cetera. This gives basic information that the court can then see who the person is. And it also guides the then questions by the attorneys on each side. From my perspective as the judge, it's really the first piece that's the most important. You bring the panels in and you have to schedule that logistically, and each panel of potential jurors gets questioned. You put them in the jury box, at least we do. You ask them the questions that you need to know the answers to. And there's what's called striking for cause that the court does, right? That I, as the judge, would have permission to do. And that is, if there's cause to get rid of a juror, it's not a strike used by one side or the other because they don't want the juror. There's a reason that I do not feel the juror is appropriate, cannot necessarily be fair and impartial, which is required. So let's give a great example. Maybe it's a smaller community and maybe a potential juror is the brother-in-law of the district attorney. Okay, strike for cause. That's just a good example. It doesn't look good. Even if that person says I can be fair and impartial, it's not appropriate to have a brother-in-law, a relative of the district attorney or of the defense attorney on that jury. So the judge has the ability to strike for cause. Either side can ask, either side can say, Judge, we want you to strike for cause. What is the reason they want the judge to strike for cause as opposed to them having to do it is preemptive strikes that the prosecution and the defense have are limited in number, different numbers, different places, different trials, but they're limited in who they can strike, how many people rather. Whereas the judge can get rid of someone for cause. And often when it's for cause, both sides agree, right? It's it's a reason that that particular person wouldn't be appropriate for this particular trial. And they're struck for cause and they leave.
And so life happens, if someone gets there and they say, my child has their college graduation, and so this trial is going to conflict with that. How does that play out? Will the judge automatically strike that person because they have a conflict?
Not necessarily. So that's a really excellent question. And there's a lot of discretion of the court. And so you don't usually just accept what you said and not do a deeper dive. Usually a court's going to do a deeper dive. All right, Ms. Hyman, please tell me, what date is the graduation? Is it here or do you have to travel? If you have to travel, how many days have you already planned to go? Because often if you just take a statement on face value, most people could conflict out of a jury trial, let's be honest. So you really have to do that deeper dive to ensure they really can't serve. Maybe they say, well, I'm just going to be out on Friday of this particular weekend. And the judge may say, well, I don't do trials on Friday. I need that for my own day for administrative in my court. So this trial is only going to be Monday through Thursday. It's like all those logistics. So I always think of the court as a manager. You've got to manage your courtroom. You've got to manage the people to make sure the law is followed. And the reality is, it's not good enough to say, I can't do it because there's a graduation. I can't do it because I'm my own business owner. They have to ask more questions and really delve into that. I want to use that example briefly as another business owner because so many people own their own business or work at home on their own independent contractor. So that may not be enough. The next questions I would ask are things like, do you have any business partners that can cover for you if you're selected for jury duty? Will you lose income if you're selected for jury duty? If you're going to lose income, how much income will you lose? Are you reliant on that income to support yourself and or your family? So almost every reason provided as a conflict by a person to not serve on a jury, I would suggest the judge has to do a deeper dive before making an informed decision.
So how if we have a potential juror that the defendants really want really badly and the prosecution doesn't want, but then the defendant gets up and tries to, as we say, rehabilitate that person to try and show that the magic words, they can be fair and impartial. How does that play out in the courtroom?
Well, it can get treacherous, right? Because each side are usually passionate advocates for their respective position. And it comes down to the court has to make that decision. I mean, I was pretty good when a former judge. So when I was on the bench, my goal was always to look at the law, make a decision, and make a very clear record. Because I always stood by, if someone didn't like my decision and felt there were grounds to appeal, that was their right. And I want to make a clear record to give them that right. So it means that attorneys are going to argue back and forth. And the reason why one says this juror should not be excused for cause and another says this should be excused for cause. But keep this in mind. At the end of the day, if I reached a decision that, listen, I think they can be fair and impartial, I'm not going to excuse for cause. My next sentence is, but state, if you really object, you can use your preemptive strike to strike this juror. That's always the option that they have if they choose to do that. But I would put on the record very clearly why I do not think it's appropriate to strike them for cause.
Let's talk about jury instructions. A lot of prosecutions say that those are key to their case. How does that play out, especially in the courtroom? Can you give us an overview of that?
Absolutely. Now, I'm assuming by jury instructions, you mean the instructions given to the jury prior to their going out to deliberate. So all the evidence is presented. And then when they hear jury instructions differs in different courts, different states, etc. But you can either give the jury instructions and then their closing arguments, and then they retire to deliberate. Or you can say, we're going to get through the closing arguments and then give the jury instructions and then they retire to deliberate. I believe the written jury instructions should always go with the jury. Not everyone does that. Not every state, place, court does that. But the important...
Why is that? Why do you think that?
Great question. And this is where people differ, judges differ. It is the law that they have to use when they're applying the facts to the law. And the law, as we know, is sometimes difficult to digest, even as a lawyer. So imagine if you're a layperson and a judge has to read, which we always do, we read out loud the jury instructions, and there's a definition of murder, and there's a definition of reasonable doubt, and there's what to do if you can't agree. You're listening to pages and pages of information. My belief is, I also want you to have those back there. So if you're talking about one of the charges, murder, and you're saying, wait a minute, what was the definition? I want to look at the definition again. If you don't have the physical jury instructions, then you're going to have to rely on the collective memory, which may or may not work. That could be difficult. So my opinion is they go back, then they have those jury instructions, which includes the definition of the crime or crimes. So they can use that to reference when they're really trying to do a deep dive and say, hey, what's the evidence? Does the evidence presented prove beyond a reasonable doubt or not? So I think they need those back there. Now, some people that I know say, oh no, they're going to be deliberating for a week because they're going to get into the nuance of every word, of every definition, and that's not the goal. So there are differing opinions.
What type of demographics, personality, job do you think that the prosecution want on this type of case?
Listen, I don't know the best answer for that. And here's why I say that. As a judge, I'm more in tune with a juror following instructions, not being fair and impartial, being appropriate, not getting struck for cause. I can tell you, Kelly, there have been so many times that I haven't necessarily understood why a particular juror looks attractive to a particular side. And so I will tell you, it's one area that I can't predict. And sometimes I think, I wonder what their thinking is to want that particular type of juror. But in general, there are things like when a person is accused of crimes against women, you're not going to want a jury of all women. And in fact, you may want a jury of men, right? And so there's that piece. Age is a factor because it may be that given the types of crimes alleged, perhaps older people may be of a different generation to think about those things differently. And if that's going to benefit you, well, then you want an older person. If you think that's going to hurt you, that people who are younger may have a more liberal or more attitude that's going to support whichever side you're on, well, then you go for the younger. So all the demographics absolutely matter. It doesn't matter to me what race they are. It doesn't matter what culture they are, what background they are. The reality is this: you never want a jury that has none representing your client. So if your client is white, ideally, if you're defending that person, you don't want a jury that doesn't even have a white on it. Same if it's African American, Asian, whatever it is. So ideally, you have to look at the demographics. Now, you cannot strike because of a race. You cannot discriminate against jurors. Those aren't valid reasons to strike jurors. It's not allowed. But I'm just saying you're going to be cognizant of, you want a jury of your peers, if you're a defendant, to be on the jury.
Let's talk about the indictment. Can you break down the indictment against him and what that entails?
Yeah, absolutely. So when we talk about the indictment, first of all, a lot of people say, why is this federal court and not state court? Because these are federal crimes that he has allegedly violated, broken, done. And what I mean by that is racketeering. That's a federal charge. Racketeering is conspiracy. When there's a leader who's using criminal enterprises to get all these other people to do their bidding, to commit crimes, right? That's a federal crime. So he's been charged under that statute. Taking individuals across state lines, sex trafficking, also a federal crime because it's across state lines. And so the indictment in this case is focused on the federal offenses that he's alleged to have committed. And the feds don't play. I'm not suggesting states do, but you know this, Kelly. The feds, they do not, as a general reputation, tend to charge people without the evidence. They especially don't go to trial to prosecute without the evidence. And so generally, when a defendant is taken to trial by the federal government under federal charges, rest assured the prosecution is well prepared to, they believe, establish the elements of the crime set out in that indictment.
So what are going to be his defenses to these allegations?
Well, that's what you don't necessarily know. We don't know that yet. So keep in mind, and I have to tell a lot of people, and I know you know this, but you don't have to put up a defense. That's not necessary. All that you want to do is create reasonable doubt, because if one juror has reasonable doubt and doesn't believe the allegations put forth by the federal government in this case, well, then that's enough to at least get a hung jury. Now, if he wants to put on a defense, he can choose to do so. But in this case, remember, he's been very vocal, as have his attorneys. He didn't do it. He didn't do it. In fact, everyone, not everyone, most everyone, at least in my world, has seen that video, has seen the video. of the girl, the victim, outside of the elevator. He's dragging her. It's pretty awful to watch. And you look at that and say, oh my gosh, look what he's doing to her. This is criminal. But do you know, his attorneys have said, no, 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 there's more to it. Other things happen before and after. Maybe she was the instigator. Maybe she did things to him first and he was reacting, even if inappropriately. That would be a whole different set of facts to prove a crime on. And so I think the reality is he's saying, hey, I didn't do it. I didn't do anything wrong. And I didn't do all these things I'm accused of.
From a judge's perspective, we're talking about the videotape of Miss Ventura being harmed. Why would the judge allow something, as some would say, so powerful? And Diddy's team is fighting to make sure that the jury don't see that. Why would the judge let that in?
Oh, that's such a great question. So every judge has to do a balancing test. First of all, is it relevant? And in this case, I think it's clear that most people would agree it's relevant given the nature of the charges against him and what he did to her in that video. But the next question for any court, for any judge is the probative value of that relevant evidence outweighed by the prejudicial value? And the judge has to look at it very closely. And again, in my opinion, make a very clear record as to the decision made by the court. But it is relevant. And obviously, the judge decided the value of this, the probative value of this, is not outweighed by the prejudicial effect. Because having a video that's hard to watch, that you react to, that is as really awful as that video is, and how much it paints P. Diddy in a bad light, that doesn't necessarily mean it's more prejudicial than probative. This is a legal test that has to be weighed. Now, the other thing a court can do is, and I don't think the court did it in this case, a court can always say, if you showed the entire video, perhaps there are different things that happen that are prejudicial, overly prejudicial. You can't include that. But this portion of the video, for instance, is relevant, probative, not too prejudicial. It can be used. But you're right. This judge decided, all right, it's probative. State, you can use it. Why doesn't his attorney want it in? I wouldn't either. Who would want that in? It makes him look bad. It makes him look bad. And most defense attorneys are going to argue it's not the whole story. That's one little clip. It is true. It's not a 30-minute video that tells us what happened before and what happened after. It's one little clip. And so any defense is going to argue it's prejudicial because it doesn't tell the whole story. The judge didn't buy that argument.
Will Diddy testify?
Oh my gosh, why would he? Why would he? Why would he? Why would he? So we know the adage is, and I've never been a criminal defense attorney. It's not in my blood. I'm not inclined to ever be one. I thank those who are. It's such an important responsibility. It's just not something I would be able to think in that way to do well. Having said that, the reality is most defense attorneys tell their client, no, you're not going to testify because you're subject to cross-examination. Every word you say, and if you've given any prior statements, if you've done or said anything they can use against you, they're going to. And how you come off on the stand completely affects what the jury thinks of you and how they weigh your credibility. And a lot of defendants, I find, choose to testify. It's the defendant's decision, but they choose to testify because they want to be heard. They want to tell their story. Well, even if they're doing that as themselves, what if their persona is not likable? And if their persona is not likable, the jury is going to hold that against them and find them not credible. Now, the opposite is also true. What if a person is very credible, very believable, very sympathetic, heartbroken about these charges, and tells such a good story of the facts as they see them that the jury buys it and they're not guilty? We're seeing that more and more in cases that we're covering. But the reality is, in a case like this, I cannot imagine that he would testify and subject himself to cross-examination, not when you have federal charges, and not when you have racketeering charges. I do not believe it would be worth the risk as a former judge for him to put himself in that position.
Do you think the jury is going to find him guilty or not guilty?
I have to tell you, if you just hear the evidence, what you expect it to be, and if we look it up and read the articles, of course, it sounds like, well, he's going to be guilty. But I don't know that yet. We haven't heard the evidence. right? There's a panel of 45 jurors that now they're going to have to go through that to pick the jurors for the trial before the evidence even begins in the case. And it depends, because it depends not only on what the evidence is, but how well the state presents, the feds, the federal government presents the evidence. It also depends on how well the defense pokes holes to create reasonable doubt in the evidence. So I really cannot say, because I would just caution anyone, even the things you hear and you see, and you may think, yeah, he definitely did it. Or you may think, no way did he do it. They're going after him because of his fame. Whichever side you think, you got to listen to what the evidence was in the trial to really have a better idea of what this jury might decide. The last thing I'll say on that, though, you never know what a jury's going to do. You never know. We just covered a case that 3 police officers in the beating of Tyree Nichols, who died as a result of the beatings, 3 of the officers went to trial, just found not guilty on all 7 charges against each of them. I was floored. And this was yesterday, and I said, I can't believe it. To the point, I respect the jury system. You never know what a jury's going to do.
Who is going to be the star witness for the prosecution?
In my mind, hands down, Cassie Ventura. She's going to be the star witness. She's the one that's seen in that video. Many, many people have seen that video. I think that's what who everyone's going to want to hear from, because they've already seen there was an altercation. They want to hear more from her. Now, there are a lot of famous people's names who did come up during the jury selection, and it remains to be seen which, if any, of those famous people are called to the stand. And I'll tell you this, those are going to be star witnesses too, in my opinion, if they actually testify for the feds.
Is there anything else that you think that our viewers would want to know about this case?
You know, I think the only last thought I have is, so many people say, where are the cameras? Where are the cameras? Why can't we watch? Well, I agree. Where are the cameras? But in federal court, there is no televising allowed, right? So we can't have it on camera. I think that's the thing people need to understand, because we all want to see it. And I would suggest that cameras in courtrooms promote transparency. You get to see how our criminal justice system works. You get to hear the evidence that's presented. I think it is so important that cases are available to the public via media, because not everybody can fit in the courtroom, et cetera, et cetera. So I think that's the only piece I would add is, yeah, we know we'd like to see it. There's some great reporters that will be reporting on it every day, but we're not going to be able to see it on TV.
Thank you, Judge Ashley Willcott, for your time and your insight. We really appreciate you being on the show.
Oh, thank you, Kelly. I adore you and appreciate your time. Thank you.
And thank you to our viewers for watching.